So tonight I have the pleasure of welcoming you to a very important and relevant presentation concerning the independence of the judiciary in Montana. Now, if that doesn't ring a bell with you, it will by the time we get done. It's sponsored by Big Sky 55 Plus with co-sponsors Great Falls Rising and Wildly United. And tonight you'll hear from 3 experts on the subject. So I'm going to start with the Honorable Elizabeth Best, who is a district judge for the Montana 8th Judicial District, Cascade County, a position she has served in since March of 2016, 10 years. Prior to that time, she was in private law practice here in Great Falls. So Elizabeth, welcome. Thank you. Next is Bill Bronson, who's a semi-retired attorney residing in Great Falls. In addition to his private law practice, Bill has served as either an elected or appointed public official in several positions in Great Falls for over 25 years, presently serving on the Great Falls Public Schools Board of Directors. Bill, thank you for coming.
Thank you.
And I just met Molly. Molly, I wrote this so fast. I'm not going to read it really fast. Okay, Molly has been a litigation director for Upper 7 Law. She was the senior legal counsel for litigation at Campaign Legal Center in DC, which worked on voting rights, redistricting, and campaign finances, including being before the Supreme Court. She taught a course on election law at Georgetown. So Molly, thank you for coming. So we really have the experts here tonight, as you can tell. And that's, to me, to have them in Great Falls and have them right here is really exciting. So we'll be hearing from seasoned and dedicated lawyers who have held tight to the independence of the courts and continue to fight for the nonpartisan elections. Now, I talked to Bill this morning because I wanted to know, how long has it been nonpartisan? When was it partisan, etc. And it's kind of interesting. Montana became a state in 1889, and until 1911, it had partisan judge elections, judiciary elections. Then a law that tried to create a nonpartisan system was thrown out by the Supreme Court. Elections remained partisan until 1935, when the Montana legislature changed the law to provide for nonpartisan elections. And folks, that was 91 years ago. Do you think we can keep it? Yes. Well, this is called Judicial Independence Are Our Courts Under Stress? Now I'm going to hand it over to our moderator, Trent Bolger, who is the ED of Big Sky 55 Plus, and he'll tell you what the rest of the evening is about. So thank you for coming.
Yeah, I want to take a moment to just thank everybody for coming tonight. I want to thank our wonderful co-hosts. Big Sky 55 is helping with this, but also Great Falls Rising and Wildly United really helped get folks out here and got some treats for us. And Jerry, of course, always helps us get the space. So everybody thank everybody that made this happen. My name's Trent Bolger. I'm the executive director of Big Sky 55 Plus. It's an organization of folks 55 years old and older, for the most part. My daughter's the youngest member. She's 11. You can join at any age. And we work together to make a life better for people of all ages here in Montana. So that's a little bit about my organization. First off, I've become increasingly concerned about hearing access. Is the sound fine for everybody? Yeah, okay. With that, I'm going to just kind of lay out a couple of rules for the road for the night, just for us to observe. We have a pretty special situation where we have a sitting judge on this panel, and sometimes because of judicial canons and codes of ethics and things like that, there may be a situation where a question that we ask might be something that goes against those or might be out of bounds. And in that case, the good judge to my right here is just going to say pass, and one of the other attorneys is going to have to deal with it, which is the benefit of being a judge, frankly. The other thing I want to propose tonight is if your question is more of a statement, please work on making it a question before you ask it, right? We're all here in the world of learning, but we want to hear from these folks as much as we can, not others. And then lastly, the best way this works with questions is Melissa and Dale have cards that if you've got questions, write them down and then flag them down and get them to me. That works the best. Towards the end of this, we'll probably get into oral questions, right? So with that, why don't we just have the panelists go down the line and introduce themselves and tell us a little bit about their role in the legal system here in Montana? Is that okay with you? Thank you.
Good evening. Thank you for being here and for inviting me. My name is Elizabeth Best, and I'm a district court judge. I'm one of 4 here in Cascade County. We preside over virtually anything you might imagine, probably a lot of felony work, a lot of family cases, civil cases between businesses and people, people and businesses, people and people, adoptions, probate, the gamut. I also preside, and I have Commissioner Wilson looking right at me right now. She's one of our mentors in our Veterans Treatment Court. I've been presiding over that since 2020. We're very proud of it. It's changed a lot since 2020. We have an active mentor program, and our recidivism rate is substantially better than the Department of Corrections, and we do a lot of good work with people getting their lives back. So I'll hand this off to Mr. Bronson.
Well, thank you, Judge. Once again, I'm Bill Bronson. I've been licensed to practice law in the state of Montana for just about 43 years now. Most of my practice, until I semi-retired about 6 years ago, was in the courtroom. I tried cases in state courts, federal courts, administrative tribunals, arbitration panels, pretty extensive. I practiced both in the state and the federal system. In 1997, I was privileged to become a member of the bar of the United States Supreme Court, and I've been involved in 2 cases at the Supreme Court since that time. In terms of what I'll be offering here tonight, though, I don't want to leave you with the impression that my views and perspectives are based solely on the courtroom. I've also had the opportunity in recent years to teach college-level courses in American government, political science, also comparative government. And unlike the vast majority of you who I'm sure have wonderful hobbies, skiing, gardening, so-and-so, I'm one of these nerds who, when I was working on my master's degree years ago, I developed a real interest in how government works, and particularly how our constitutions work, both at the national level and in Montana, because when I was coming of age, our new Montana Constitution had just been adopted by a very thin margin. People forget that, we almost lost it. And it's a fascinating document, not only because it's new, but because it goes into a lot of subjects that our national Constitution doesn't go into. And consequently, it's a very controversial document. And so some of what I think all of us will be discussing this evening will be shaped by the kinds of experiences I've had, and I know my colleagues here have as well.
Thank you so much. I'm Molly Danahy. I am the litigation director at Upper 7 Law. We're a nonprofit, nonpartisan law firm based in Helena. And our mission is to hold the powerful accountable. And we do that primarily by bringing cases to protect constitutional rights, whether that's under the Montana Constitution, which I have recently become very familiar with in my work with Upper 7, or under the federal Constitution, which is where I did a lot of work in my prior practice at Campaign Legal Center. I'm really excited to be here. We practice a lot in Montana courts, a little bit in federal courts, and have a kind of wide variety of cases that we bring depending on what the constitutional provision is or claim is that we're trying to defend.
So just to get us started off, this question's for the attorneys, because really, in the most fair world, a courtroom is a neutral space for your clients, whether you're on one side or another. It's a neutral place to figure out what happened, or what side of the truth you fall on, right? So why does judicial neutrality matter to your clients when you walk into the courtroom?
Well, to answer this question, most, if not all of you, I'm sure, have seen the statue of the woman dressed in classical Greek garb, and she's wearing a blindfold. We talk about Lady Justice, or Justice is blind. And that principle is derived from the fact that we are accustomed to, in this country anyway, the idea that when we walk into the courtroom, no one has prejudged our positions. Each party to the litigation has the opportunity to present their case as fully and fairly as possible. These are ideas that are not new. Our legal system was not just created in the late 1700s. It's founded upon principles that go back, quite frankly, thousands of years. If you pick up the Hebrew Bible, you will find many of the elements of our current legal system in there, all based upon what we might call ideas of fundamental fairness. And with that in mind, as practicing attorneys, we expect the system to reflect those values. We expect the judges to adhere to those standards. And for the most part, they generally do. We expect our opponents in the courtroom to adhere to them as well. And when you're arguing cases to a jury, individual citizens in your area, we anticipate that they will judge the facts in accordance with those principles as well. It's nothing strange, it's nothing unusual, it's an expectation, as I say, that's been built up over centuries. And that's what makes our system one of the best in the world.
I 100% agree with everything that Bill said. And I think also, when you walk into a courtroom to represent your client's interests, you want to be able to tell them that this isn't just a pro forma thing. This is their opportunity to be heard in a neutral forum and have the opportunity to present their case and have it heard and weighed without bias and without prejudging, as Bill said. And I think the really critical thing, especially if, not every case is going to follow the same set of patterns, and we bring a lot of cases sometimes that have novel interpretations of constitutional law or things that haven't been decided before. And I think that's something that's also really common in the practice of state constitutional litigation, just because there's not quite the same depth or body of precedent as there is at the federal level, just based on my observation in doing work on both cases, both sides. And I think you want the opportunity to be able to make your case to someone and be able to make your client's case in a way that, even if it is a new proposition or a new interpretation, it's going to be heard and valued and measured against the existing body of law, the constitutional text, the statutes that you're raising, in order to either push the law forward in a way that is fundamentally fair and protects the rights of the litigants, or maintains a precedent or maintains the body of law as it currently exists in that same manner. And so that doesn't mean that you're walking into the, litigation is an adversarial process. It is necessarily one person versus the other side, one side versus the other. And you want a fair shake when you go in to that system. It's the same thing as going to a Grizz Cats game, you wouldn't want a referee in that situation that had, been a lifelong Grizz fan if you're a Cats fan, for example. And so I think it's that same principle of fundamental fairness that you see not just in the long history of the legal profession, but in our approach to adversarial competition of all kinds. And I hate describing litigation as a competition, but I do think that's just a nice analogy. So.
And with that, I'm going to ask the referee here what she thinks. What does a fair and impartial? What does fair and impartial mean when you're trying to keep control of a courtroom situation when you're deciding from the bench?
I don't think that it's any surprise that it means that people expect us to be objective and to listen and decide the case based upon the facts and the law, and that requires us to be prepared for a hearing and also, or a trial, and also to be ready to respond to very difficult questions. One revelation for me, I practiced as a trial lawyer for, 35 years, I think, before getting on the bench, and it never occurred to me how it looks from the bench. And what it looks like is real people who are all in some sort of a crisis, and everyone in the room needs to know that the judge sees them and cares about them as human beings and cares about the crisis that they're in, and it really doesn't matter what side they're on. And the lawyers need to know that too. They need to know that you're coming to the courtroom with everything you've got, and just to try as hard as you can. Judges get things wrong. I have gotten things wrong. I'm confident. I'm not perfect, but you have to try hard to apply the law to the facts and to understand what the law is, which can be sometimes very complicated. And the facts can be very complicated. So I think being objective means to have a decent and fair approach to life, and to remember that at least figuratively speaking, we all grew up down the street from each other. No one is better than anyone else. And I think sometimes people with wearing the black robes or sometimes blue think that gives them some sort of a patina of being special, and it doesn't. You should be bringing some experience and some training and some intelligence to the bench, and you should bring some humility. And that's what it needs to be. We have, I think, 56 judges. Someone may know better in this state right now, and then I think the last numbers I heard were in 2023. Our district court judges handled 50,000 cases. You do the math. We are in a busy district. The federal courthouse is the fancier one. It's not fancier, it's better maintained. But by a long shot. But one busy district court judge, and that would include our district, does more work than all the federal judges in the state of Montana combined. So just to give you a sense of, and in that year, of those 50,000 cases, only 800 were appealed. So I would suggest to you that you should be pretty proud of your district court judges.
Yeah, and on that point, there's a conversation that's happening outside of this room about trying to put partisan labels on judges. And so my question for the attorneys here is, how would that affect ordinary Montanans and how they view fairness in the courtroom?
Are you asking me?
Well, if you want to comment.
I'll start just because I've got the mic. And I'm not the ref here, but I would suggest to you that you consider if the thumb is on the scale based on what party or faction you belong to, then what the logical extension of that is that if you don't like what a judge did because it didn't comport with your view of the world, then you don't follow that order, you defy the court's order. So what happens if we have a divorce case and the judge orders child support and one party didn't like it, which happens, and they don't, 50% of the people every time are gonna leave the courtroom unhappy. It's just math. And so if they don't like it and they don't follow our order, then what? If the sheriff doesn't agree with a sentence that I impose and refuses to lock up a defendant, then what do we do? Because his view of the world is different than what he thinks my view of the world is. So I think that's the problem and the concern.
I think one of the problems with partisan labels for judges, and I see this also in, when we talk about federal judges and federal cases, we look first to see who they're appointed by before looking at what the decision is. It just creates this shortcut, and it makes it so that people don't feel the need to engage with the actual substance of a judicial decision or a case or the controversy that started it, and they can just say, okay, well, I see who appointed this person, or I see the partisan label that's on this judge, and I know why they did what they did. And I think that does a real disservice, not only to a lot of judges and the opinions that they write, but also to the citizenry, because you're not actually engaging with the substance of the decision in the same way that you would if you don't know any of that, right? And it doesn't immediately trigger your associations with a partisan label or a partisan position. And so I think that's one really critical problem with partisanship in creating those labels in the judicial system. And I think also there's a perception, at least, of a lack of independence in that situation, because if you are reliant on a partisan label or a partisan affiliation in order to be elected, then there is going to be a presumption of some sort of like that you owe something to that party or that partisan movement or positions in order to get your job, and that there is some that is going to influence your decision, especially in an electoral system where you have to keep going back to the voters and convincing them that you were the right person for the job. And so I think that also does a disservice to judges and to the legal system itself, which should be free from those sorts of associations and assumptions about why someone is doing the thing that they're doing or why they've issued the decision. And I'm not naive. I think that there is, those things do affect how some judges issue decisions or how they reach the conclusions that they reach. But I think the more we pull away from constantly defaulting to that first frame of reference when you're examining what is happening in our legal system, then I think the better off we are, because we're going to be more curious and more interested in the actual substance behind the labels.
I think there's two things that are in the background of this whole conversation when we hear of this new interest in attempting to elect our judges on a partisan basis. And both the judge and Molly have alluded to some aspects of it. I'm just going to expand on it for a couple of minutes. The first consideration is this conversation is being generated not because of a lot of the typical things that the judge and I are engaged in our type of practice in our daily world. There is not a Republican versus Democratic way to decide divorce. There's not a Republican versus Democratic way to decide a parenting plan or interpret a contract or even decide whether a person charged with a crime is guilty or not. What drives the conversation are concerns about much bigger issues, if you will, or bigger policy questions that usually involve interpreting either our national or our state constitution. or more often than not, a difference of opinion between the judiciary and the legislative and executive branches of government on how particular powers are to be interpreted and carried out. That leads into the other consideration. We always have to keep in mind that our court system is part of a tripartite system. We've all learned about the separation of powers between executive, legislative, and judicial. One of my favorite things to read on this subject, and it's not new, it's very old, but it is still as valid and as important today as it was in 1787 and 1788 when it was written. Most of you know it. It's called the Federalist Papers. Alexander Hamilton, James Madison, and in a few instances, John Jay, wrote a series of essays designed to convince the New York State Convention to adopt the new Constitution that had been drafted in Philadelphia throughout 1787. And it goes into great length in talking about why we are trying to develop a system of separation of powers. And when you read the essays that talk about the judiciary, you see the foundation for what we're ultimately discussing here this evening. Courts are there for a reason. They are not representative bodies, and they are not intended to be. They are intended to look at the important questions that arise in our society in a very different way than legislatures and executive branch officials do. There are different rules. There's an entirely different deliberation process. There are express rules of conduct that in many instances do not exist in the relationships within legislatures and governors and attorneys general and so forth. So the question you have to ask yourself then is, when somebody is proposing bringing partisanship, partisan labels, political party labels, as we understand them today, into our judicial system, the outcome, I guarantee you, will be the destruction of the integrity and the purpose of the judiciary as we know it. And if that's the case, then what does that mean for the separation of powers, the doctrine that supposedly all of us, regardless of our political differences, espouse as an ideal? Well, we know what the answer is. It ultimately leads to the desecration and destruction of our system of government. That's not a wild allegation. That's the God's truth. And so when we hear this conversation, if that's the ultimate outcome, imagine how the public, the average person, looks at it and experiences it when they know that process is happening. They will have no confidence in the court system, or very little. And once that happens, again, it's part of that destructive process. So, just some ideas to think about as we move forward here this evening.
So not that I'm buying the premise of this holding judges accountable, or we need to know more about judges because we don't have some idea of how they're going to rule or anything. But my question for the judge here is, how do you know whether a judge is good? How can you pick a good judge, because we do elect our judges, right? And how can you tell if a judge is maybe not so good?
Well, I'm never short of opinions, but I think it's hard for voters, and what I tell lawyers is that they should be telling their clients and their friends something about judges that they know. But a good judge, in my estimation, and I think there's plenty of lawyers in here that can tell me if I'm wrong, but that you need to have experience. You need to have experience in the courtroom. You need to have some native intelligence, and you need to have a work ethic. It's not a glamorous job, and it's the best job I've had in the world. I'm not complaining. It's the best job I've ever had. I get to interact with people daily. I get to interact with kids, criminal defendants. It doesn't matter. It's just a wide variety of people, but you have to have an interest in the human beings that you're working with, and you have to have the relevant experience. We have judges in this state who do not have trial court experience or do not have a work ethic. I don't know how you find that out other than to ask people who work with them. You have to be willing to work hard. I work weekends. I get up at night to sign search warrants just about every single day. We do, I think this county does about 1,000 search warrants a year, so that's what's going on in the other layers of society when you're asleep. And so you just have to be willing to do that non-glamorous stuff, but if you haven't been in the trenches, as many of the lawyers here have been, and if you don't have that perspective of being a lawyer trying to prove a case, you don't understand when you take the bench what it's like, and you don't understand why it's not a good thing to sit on a case for months or years or longer without making a decision. We can get things wrong, but there's a Supreme Court that you can appeal to and who can resolve things that you think are wrong. But judges need to be brave enough to make a decision and hardworking enough and experienced enough to know how to do so. That's what I think makes a good judge.
I don't know much more I can add to that. Obviously, I get questions many times every 2 years when someone is running for a judge position. I receive calls from clients, friends, and others, and they asked me point blank, they said, who should I pick? And in a lot of instances, I will tell them who I'm voting for, but I said, regardless of that, I said, I want you to focus on exactly the things that Judge Best was talking about. What type of experience do they have with the legal system? How are they perceived overall by their colleagues in the profession? It's much easier in, say, a district court or a JP court race when typically lawyers, people get to know how the legal community views that person, whether they're an incumbent or whether they're a challenger. But it all boils down to experience, integrity, temperament, these general qualities that any of us would want to see in a judge. As to Molly's point that she made earlier, you want to know when you're in front of that judge that they have all of those characteristics, despite any biases or prejudice that they may have had in their life. They are prepared to set those aside and listen to what you and the other side have to say before making a decision, and to be as objective and fair as possible.
I think one of the things that I always struggle with when I'm looking at judicial elections is the lack of information about judges. It's very difficult to find, I think as Judge Bass mentioned, most of the cases that she deals with and that our district court judges are dealing with are just everyday, day-to-day things that affect individual people's lives, whether that's criminal defendants or people going through family law situations or what have you. And those things don't make the news. There's no easy way to find out what a judge's record is on cases like that and how, unless there is some big splashy criminal case or something like that thinks that the state might use, it's really difficult. And I think that's one of the things that is sort of appealing about this argument that we need more information about judges is we need this partisan label, as I said, which provides that shortcut to you think you know how this person's going to decide because of partisan label that's attached to them. But what is really important, what would be really much more effective and efficient is reporting or studies on what the decisions are that judges are issuing and how those are affecting communities and members, not at the big, national news level cases, not the U.S. Supreme Court cases necessarily type of thing, but genuinely, what is this judge's track record? How long does it take for a case to make its way through the judge's court system before someone gets final resolution? Because litigation, especially civil litigation, is it takes a long time. And it can be years before someone gets resolution on their cases. And one of the reasons for that is because of just the volume of caseload, especially that state courts handle, and the fact that they're handling criminal and civil litigation at the same time. There's very solid reasons why criminal cases have to proceed on a quicker timeline in the federal court system. We have the Speedy Trial Act that ensures people aren't languishing under the threat of criminal proceedings, and they can get to finality quicker. And so I think that sort of information is so much more helpful in evaluating a judge's performance and evaluating who is someone that is a candidate that you want to see stay on the bench or be elected to the bench, than this sort of easy default shortcut of partisan default.
I'll also add that we need more women.
I think you one-upped me on what I was going to say there, Judge. I was also going to say, we're in a unique situation. Now you're really trying to be a moderator in these things, but we're in a unique situation where 2 out of the 3 branches of our government just doesn't listen to their attorneys. Like, they know that in the legislature they are passing unconstitutional bills. They know at the governor's office that when they sign it, it's unconstitutional. So this rage that they fake about their bills being overturned, they know that this is going to happen if a judge is doing their job. So for me, I know that the first judicial district in Helena is doing their job because it is plugged full with cases that they have to hear from the darn legislature. And unfortunately, 2 of the 3 of our branches of government are not all upholding their oaths of the Constitution, right? So that's just my personal take here. I would look for in a judge somebody who's going to follow the law, going to follow the rules, and has the courage to do so, regardless of whatever pressure they're being put on.
I agree. I'll just say that Bill's friend Alexander Hamilton called the judiciary the least dangerous branch is because it's the weakest. The legislature has the purse strings, it has all the money. The executive has all the ability to force and to imprison and to bring weight to bear against citizens, but all we have, as Hamilton said, is merely judgment. And I'd like to just add that what you just talked about, Trent, this is a dangerous time. We hear a lot about the federal judiciary. We don't have any security in our Cascade County Courthouse, literally. It's become a very dangerous time. I get accosted when I'm out in public. This is a rare event for me these days because I don't know who to trust. And people attack judges. I got off Facebook 7 or 8 years ago because I just couldn't handle the attacks. They attack us for our decisions. They attack us, and the rage is real, and we feel it. We had a sentencing this week where we did have a lot of law enforcement presence because the people had been so ginned up about what they thought the sentence was going to be and what they thought it should be, and they had no idea what the case was about really, other than what was reported in blogs or Facebook or whatever. That it's made for a very dangerous time to be in the judiciary. And it's not just the judges, it's our staffs who sit in front of us. It's the lawyers who are in and out of the courtroom day in and day out. It's parties who are coming in to get marriage licenses. People don't care, they're under enormous stress. Everybody, by the way, seems to have a gun and is loaded. And I am not kidding. We have kids every single day that I see who have, you know this, they're shooting each other, they're shooting adults. Everyone's got a loaded weapon, and if they've got a loaded weapon, they have either whiskey or meth or something on board. So it's a dangerous time. I took a plea from a young woman, a 21-year-old, a bunch of dummies went out to a fishing access, and they got into an argument about parking space or something, everybody pulled out their weapons. And they had kids in their cars. And they're waving weapons around. And it's just unbelievable to me what's going on here. And it's a dangerous time. So when I get accosted at a gas station, I don't know if someone's going to pull out a gun. More likely than not, they're packing.
Well, thank you for. Tonight I'm not packing, so that we're going to be okay. I just want to remind everybody, the Melissa and Dale will pick up your cards if you wave them at the very tall redheaded guy, and Melissa, wave your hand with the hat. Melissa's got the hat on. So I guess my question is for anybody who wants to take it, or all panelists here. So my question would be, what's your opinion of who's the most at risk if the judiciary becomes political, right? Is it powerful interests, everyday Montanans, somebody in particular?
It's our citizens, our regular citizens, Montanans.
This may be a good time to share a favorite quote of mine I pulled out from a Montana Supreme Court concurring opinion from a few years ago. Some of you in the room knew or still know Dirk Sandefur. He served as a district judge here for a number of years. And he was a Montana Supreme Court justice for 8. He's now retired and doing mediation in Flathead. But in a case that was decided a few years ago, and it was a very contentious dispute between the court and the legislature over the legislature's attempts to intrude upon information that was within the judicial branch. The court came down pretty hard in its ultimate decision, but I love Judge Sandefur's comment in his concurring opinion because I think it answers the question in the best way possible. This is what he said. He said, regardless of competing interests pertinent in the two political branches of government and society in general, and he's referring to the legislature and to the executive, or the dominant will of any majority political faction at any particular time, the continued survival and vitality of our constitutional democracy and all of the personal and societal freedoms, protections, and other benefits it provides depend on the preservation of and respect for the distinct functions of all three co-equal branches of government, without any usurpation or interference with one by another. This simple, self-evident principle is more important than ever, when as now, he's writing in 2021, but I think you can agree it applies in 2026. When as now, a single political faction overwhelmingly controls the two partisan branches of state government, rendering it quite expedient to irresponsibly attack and attempt to undermine the only nonpartisan branch in an effort to attain unitary, unfettered, in effect, authoritarian power, unconstrained by constitutional limits. I think that says that.
I have a really hard time disentangling this question from the question of campaign finance regulation, and I think until you have actual campaign finance regulation, there is no way to say anything other than that powerful interests are the people that would benefit from increased partisanship in the judiciary.
All right, so I've got a couple categories of questions from the audience here, so we're going to take a couple of these. This one I think sums up about 3 questions that got asked here. So in your opinion, do you feel that the U.S. Supreme Court is making partisan decisions on cases before them in partisan ways based on who appointed them? could this be an example of how partisanship in their decisions could happen here in Montana?
Yes.
There are cases that you can point to where that very seems to be the case. I think it is a slightly more complicated question. There are always cases, even at the United States Supreme Court, where you find strange bedfellows and people are able to still reach across the aisle. I think that's becoming increasingly rare, and that's deeply unfortunate. But it should not be the case. It should not be the case that that is a question that we need to ask, that is a question, that is an assumption that people have, that is, or the one that is borne out by the decisions that the U.S. Supreme Court makes. And, you know, I practiced redistricting law before I came to Montana, and we had a major U.S. Supreme Court decision this morning that changed the entire landscape of how Voting Rights Act claims are going to go forward if they even can. And I think it's really unfortunate to have partisanship infect the process by which we engage in democracy, and not just the process by which we compete in the marketplace of ideas or what have you. So.
Let me answer that by telling you this is a classic example of why lawyers go into, and I love the judge's response, but a lot of times as lawyers it's a little hard to say yes or no to a question like that, particularly when, like myself, and I think Molly is too, we are members of the bar of the United States Supreme Court. So these guys are, men and women are our bosses in effect, and can judge us by our conduct and what we say about what they do. I remember a wonderful man, John C. Harrison. He was a justice of the Montana Supreme Court for many years. And Judge John used to tell us when we were law clerks, he said, I'm going to tell you one thing about when you get out of here. He said, if you don't like a decision that I or the other judges have rendered, you can call me up and you can rant about it. Call me up twice and it's contempt. So in order to avoid the possibility of contempt, let me answer the question this way. I think it's fair to say that throughout the Supreme Court's history, going back to the earliest days of its operation, it has always raised questions in the minds of the general public, the Congress, the executive branch, whether or not it is really performing in accordance with what the reasonable expectations were of its role in our system of government. There are many decisions of the U.S. Supreme Court in our history that I think we can all now say do not do us any good and they do us shame. Dred Scott. There is no right that a black person has that a white man is bound to respect. Separate but equal, Plessy versus Ferguson. Yes, the 14th Amendment says this, but it's okay to have a separation, which implies discrimination, which implies inequality. I could list a number of other cases that most of us have heard of or maybe have experienced through the years. I think we're seeing some of the same things today, and I read some of these more recent opinions of the court, and without showing any disrespect to the authors or to the majorities, I wonder, how will those opinions be reviewed 50 or 100 years from now? Will our descendants look at those decisions the same way that we look upon decisions of Dred Scott, Plessy versus Ferguson, and others, and come to the same conclusion? So it's probably easiest to say, when you look at them today, keep a long-term perspective. And remember where we have been, where we are now, and what we will likely, or what our descendants anyway, will likely say about these decisions in the years to come.
I would just add that I think that the problem that we have is that when people think we are partisan, they don't trust us. And when the trust is fomented, as it is being done right now, then we have little use to a lot of people. People, if they don't get the answer they want, they think that it's because of something else that we have picked a team. And that's dangerous territory.
I think this question kind of goes into this trust issue with the court system as well. And it's how often, I don't expect you to know the exact percentage of this, but how often, what percentage of precedent is broken in case law? County, state, national. Today it seems to me that a lot of precedent is being ignored or overturned at the federal level.
I'm not going to comment on that on the federal level, but I can tell you that we view, I think, most responsible judges view our job as being applying the precedent that is in existence at the time that we are, the argument is made to us. And so that's our job. If it's going to be changed, if the precedent's going to be changed or reconsidered in light of the Constitution, that's going to be done at another level. So, again, these accusations that are made are generally made out of whole cloth, and then they're put out on Instagram and Facebook, et cetera, and people believe these sound bites. And then they think that they have corrupt judges per se. It's pretty hard, it's like the old saying, every time you can keep protesting, but thou protestest too much. And if I keep saying, well, I'm not doing that, people will just suspect, well, it sounds like she is to me.
Ditto.
I don't have anything to add.
Very good, Elizabeth.
What do we think in the audience? One or two more questions?
Yeah.
We got a couple more? Okay. All right, so what do you think about the perception of activist judges? It seems to me because many people believe that this premise, they believe that we need to have partisanship so it would be more fair.
These are these code words for that judge didn't decide in my favor, so they were activists. I don't even know what that means. It's just a code word. It's a dog whistle to make people distrust the judiciary.
I agree with that, but to bring it a little bit closer to home in Montana, one of my personal opinion from having read a lot of these decisions that seem to excite certain members of the executive and legislative branches, we have to remember in the context of Montana that we have our own constitution. It is not the same as the U.S. Constitution and its amendments in many particulars. We have a number of additional rights in Montana that we as citizens can hold against our government. There are some expectations placed in the legislative and executive articles of the Constitution that don't exist in the U.S. Constitution. For example, in Montana, Article 10 of our Constitution addresses our education system. The expectation that the legislature shall provide a system of free public education, provided in accordance with the principles of equality of opportunity. I think what's happened in recent years is when you look at some of the courts, or Montana Supreme Court's decisions that are very controversial, they are just simply trying to do what John Marshall first did when he ruled in Marbury versus Madison in the early 1800s. I have to take this document as it reads and I have to expound on it in the broader context of what our system of government is all about and what should be the ultimate outcome here. So, as examples. In Montana, if our document says, which it does, that you have a right to a clean and healthful environment, the legislature and the executive cannot ignore that. You have to come to grips with it, which means not that the court is going to adopt all the particular regulations, say on air and water quality or sanitation standards and so forth, but the court is going to direct these other branches to at least address this in a meaningful way. In the area of public education, we have had 2 major lawsuits in the last roughly 40 years dealing with the meaning of those clauses in the education article. And bluntest way to say it, those 2 lawsuits came about because the legislature didn't get it. It had an obligation to proceed and develop a system of free, quality education. To be very honest with you, we may have a 3rd lawsuit within the next few years if we don't address some of the growing inequities in our education funding system today. So if somebody comes to me in those instances and says, well, the court's just being activist, I say, well, again, as Judge Best said, these are code words, these are dog whistles. What you're really objecting to is the court's best effort to expound upon the meaning of words in a written document that a majority of the people of this state adopted in 1972. That's our job as a court. And in those particular instances, I don't have a lot of use for those kinds of criticisms, because until the other 2 co-equal branches of government are willing to step up and address our Constitution as it is written, then there's no basis for the criticism.
I agree wholeheartedly, and I think, again, it's this shortcut that allows people to avoid critical thinking and avoid actually confronting what the substance of a judicial decision is, or what the substance of the Montana Constitution is, and actually wrestling with the idea of, if the Constitution says this, then what is actually wrong about this decision, or is it just that I don't like it? And I think it provides an easy way to stay comfortable and stay siloed and say, well, I agree with this set of people, and they're saying this thing, and they say this is an activist court or an activist judge, or what have you, and so we need to know that they're not in the pockets of one party or the other, so we can trust their decision making. And I would say what would actually allow you to trust their decision making is to understand the constitutional principles and the decisions that are actually being made, and to look at those. Law school is a very expensive way to learn how to read judicial opinions, but they're very accessible. The Montana Supreme Court has its opinions on its website. The U.S. Supreme Court has its opinions on its website. You don't need a big fancy Westlaw account, which is a lawyer thing, in order to access those things. You can actually read those decisions yourself. And I think it's critical to do that and to understand the context that these decisions are being made in, as Bill discussed, because otherwise you're just relying on these shortcuts to, again, further silo yourself into the way of thinking that already feels comfortable, that already reinforces the things that you believe, without actually confronting difficult conversations or difficult ideas.
So this person that has asked 3 questions based on the handwriting, so I'm really going to get to one of them for him. So what do you think about this idea of another constitutional convention, state constitutional convention that's being floated around? I'll answer this. Every 20 years we have to vote on whether we like our Constitution or not. So I will.
That's in the Constitution.
It's in the Constitution. And that's going to come up in 2030 again. So I'm voting to keep our great Constitution.
Well, I think it's a great constitution too, and I know other lawyers have been at, and judges have been at conventions and meetings where people have come up to me from other states and said, see your name tag, say you're from Montana, you have a great constitution, we wish we had your constitution.
As Trent said, we have no choice. Our Constitution, as adopted, requires this review every 20 years, and so we will have to vote on the question. The way I feel about our Constitution today, I would vote no. I don't see any reason to change the document as a whole. There are some provisions of it that when they were adopted, I still question a few of them, but that's not a reason to change the whole document. And one thing I would mention, and some of you folks probably are already aware of it, there are individuals out there who are beginning to lead conversations about the need for change. And that's fine. You can put your positions forward in 2030 when the issue comes up, but pay very close attention to some of the things that they're talking about. Pay very close attention to the people who are making those arguments. What I see is a return to the same kinds of special interests, arguments that put this state in a very difficult posture for a number of years because of the things that were written in the 1889 Constitution, which was written in many respects to protect the mining interests of the state. Whenever you have a document that is designed to protect a particular economic interest, as opposed to the broader interests of the public at large, beware.
I am gonna hope Trent indulges me on this, but one of Upper Seven's non-litigation focuses is constitutional education, and we have a program called the Montana Constitution Roadshow that travels around Montana and educates people about what is in the Montana Constitution and also the history, touching on some of what Bill just mentioned, of how we arrived at the 1972 Constitutional Convention and how that document took shape and was enacted. And one of my favorite things about the Montana Constitution is that it does reserve all power to people, and one of the ways it does that is by making sure that every 30 years we have an opportunity to decide whether we want to keep that Constitution. And it also does it by providing a more limited mechanisms to amend the Constitution through ballot initiative or referendum that don't involve replacing the entire thing. And those are some of the things we talk about during the Constitution Roadshow, and we don't take a position on whether there should be a constitutional convention or not, but we do think it's very important for citizens of Montana to understand the history of the Constitution, what is in that document, and know what they're voting on when they go in 2030 and see that question on the ballot.
Well, since I'm sitting up here with a bunch of attorneys and they charge by 6 or 10ths of an hour, I'm going to ask them in one sentence, what should everybody walking out of this room remember about why impartial courts matter? Why impartial courts matter in one sentence? I'll give the judge 2 because I might get in trouble in Cascade County at some point.
Well, I think we all know why they matter and why a nonpartisan judiciary matters. We need to be able to trust our judiciary. The judiciary is the only branch that stands between us, real people, real Montanans, and tyranny. So if you choose judges that you can trust and who you can trust, and I hope you can trust me, then you should protect that institution.
I know some of you in the room know that my mother was an English teacher here in the high schools for a number of years. And when I was thinking about how do I put it in one sentence, I was conflicted between making sure it was grammatically correct. And in doing that, how could I put as much into one sentence with commas and semicolons and still call it one sentence and have it pass her judgment? So here goes. We owe it to ourselves and to our posterity to support and ensure the continued viability of the separation of powers doctrine, which requires us to respect and support the constitutional prerogatives of each branch, and which in the case of our judicial system requires us to support election or appointment of our judges without regard to partisan political alignments and interests, is the best guarantee of continued viability.
For me, I think it's quite simple, and Judge Best talked earlier about the mathematics of litigation. 50% of the time, someone is going to lose, and you want the person who walks out of that courtroom unhappy to be unhappy that they lost, but not unhappy with the process. They need to be able to understand that the decision, that the judgment that they lost is one that is fair and impartial, and that they had a fair hearing, that they had the opportunity to make their case. And at the end of the day, the facts and the law were on their side, and that there wasn't some other consideration that went into making that decision, that went into that loss.
I want to go ahead and just thank all of you for hanging in here with us. I want to thank our panelists. I want to thank our sponsors, Wildly United, Great Falls Rising, and then I also want to thank the good folks here at the Dark Horse and the Celtic Cowboy for hosting us. So. Oh, and Jerry's got something apparently.
You know, there are always those last minute things. But on Thursday, May 14th, Upper 7 Law is going to be back in Great Falls with a road show. So, if you haven't signed in, please do. All three of the organizations that are represented, as co-sponsors, will be sending it out. So if you are on at least one of those lists, you'll get it. If you're not, please be sure you check Great Falls Rising, whatever you're doing, and we'll be sure that it gets out to you. So I want to thank Trent and our panelists today. This was outstanding. Thank you.